that answers the most difficult question he raised. Can we apply a law that was enacted in 1980 today? The answer is yes, and the reason is Section 7 of Schedule 6 of the Constitution. To that extent, Section 94 of the Penal Code, which was enacted in 1980 and which provides for the offense described in the charge sheet, then is still applicable today. And then there's another fundamental argument, again in its element, that one, you are at the same pedestal with the Parliament by dint of Article 10, that's correct. But that Parliament has been negligent, and that because of their negligence, don't be negligent, help them out. Interestingly, the suspect is a member of Parliament. It's very interesting. So that the suspect it was negligent, leading to charges against her. But that is by the wayside. Now, Article 2, which Senior Counsel refers to, and I'll refer the court to Article 2, I think sub-article 2 of Article 2, let me just look at it. And it says, no person may claim or exercise state authority except as authorized under this Constitution. You have no powers to make law. You have no powers to repeal laws. You have no powers to amend laws. That power belongs to Parliament. That Parliament which is inept and or negligent, in the words of the defense, is the only authority under this Constitution to make, amend, or repeal laws. And related to that, therefore, is that as long as that law has not been repealed, it remains part of the law of Kenya. And if that argument is correct, and I believe it is correct, then the argument about Article 50, sub-article 2N, which is a very easy one to answer as we go on, that every accused person has a right not to be tried for an offense in respect of an act or omission, N, not to be convicted for an act or omission that at the time it was committed or omitted was not an offense in Kenya. This offense is an offense in Kenya since 1980. So until it is repealed, this court and the Office of the Director of Public Prosecutions has an obligation to enforce the law. There were very many fundamental issues of the Constitution. That's why I've taken some time on it. Then there is the question about Article 52B, which I'll marry with what I've just said about 52N. I have tried to persuade other benches of the judiciary, and I will try to persuade you today, that there was a deliberate intention to separate Article 49 and Article 50 of the Constitution. This is what I teach my law students at the Kenya School of Law in my guest lectures. That it was deliberate to separate the rights of an arrested person vis-a-vis the rights of an accused person from a commonsensical look of the Constitution. So that when Senior Counsel started giving his opening speech, he says, no, I should not call her accused, let me call her suspect for now. And which I agree with, that we are dealing with a suspect, not an accused person. Then that, if I persuade you, takes you outside Article 50 of the Constitution.